Hello. In this presentation, I will identify the purpose of the Individuals with Disabilities Education Act and discuss its subsequent amendments. I will give a chronology of amendments through today and identify key aspects for each amendment that add value to IDEA. This presentation will also identify, analyze, and explain the 8 key components of IDEA, looking specifically at how these components affect the provision of education for students with disabilities and how they generally improve public education. In the early 1970s, before the enactment of Public Law 92-142, also known as the Education for All Handicapped Children Act, many individuals with disabilities, such as mental retardation or mental illness, were not being educated or given opportunities in line with the 14th Amendment of the Constitution and laws passed during the Civil Rights Movement. The purpose of the Education for All Handicapped Children Act was to improve how children with disabilities were identified and educated, to provide an evaluation process, due process hearings, and protection and financial incentives from the federal government to the states and local school districts. In 1990, the Education for All Handicapped Children Act was changed to the Individuals with Disabilities Education Act, or IDEA. Since 1990, there have been many amendments made to this act to improve the quality of services provided to students with disabilities. The purpose of IDEA is to ensure that children with disabilities receive a free, appropriate public education, or FAPE, with the support of special education and related services. Individualized programming is also provided for students to meet their unique needs and to prepare them for continuing education or independent living. Government funding and parent involvement are crucial to the purposes and focus of the IDEA. The chronology of IDEA begins in 1975 when the Education for All Handicapped Children Act became law. In 1990, the name was changed to the Individuals with Disabilities Education Act, and IDEA at that time received some minor amendment changes. In 1997, IDEA received significant amendments. First, the definition of disabled children expanded to include developmentally delayed children between ages 3 and 9. It also required parents to attempt to resolve disputes with schools and local educational agencies, or LEAs, through mediation, and provided a process for doing so. The amendments authorized additional grants for technology, disabled infants and toddlers, parent training, and professional development. IDEA was amended by the Individuals with Disabilities Education Improvement Act of 2004. There were several provisions that aligned IDEA with the No Child Left Behind Act of 2001. This authorized 15 states to implement 3-year IEPs on a trial basis when parents were in agreement. It drew on the report of the President's Commission on Excellence in Special Education, and the law revised the requirements for evaluating children with learning disabilities. More concrete provisions relating to discipline of special education students was also added. In 2009, the American Recovery and Reinvestment Act included $12.2 billion in additional funding for special education services. In 2009, the Americans with Disabilities Amendment Act was signed into law and became effective. IDEA began as the Education for All Handicapped Children Act in 1975. An amendment to that act, passed in 1986, provided infants and toddlers programming, which later became Part C of the IDEA amendments of 1997. Through these amendments, grants were provided to states for all qualified children ages birth to 2 to receive special education and related services. Once a child reached the age of 3, they would be entitled to receive services under Part B of the IDEA. Infants and toddlers identified with developmental delays, cognitive, physical, communication, social, emotional, or adaptive delays, or those who had been diagnosed with a physical or mental condition that might result in a developmental delay, were qualified to receive educational services under Part C of the IDEA. Since 1975, the EAHCA underwent many other numerous changes. These changes have afforded more rights and protections to students with disabilities under IDEA. The following 4 acts saw significant procedures and protections for students with disabilities: the Handicapped Children's Protection Act, the Infants and Toddlers with Disabilities Act, the Individuals with Disabilities Education Act of 1990, and the Individuals with Disabilities Education Act Amendments of 1997. The Individuals with Disabilities Education Improvement Act of 2004 also included changes that were incorporated into IDEA as amendments and not as separate laws. IDEA amendments in 1997 consolidated the law's 8 parts into 4. It made additional changes that 1. Gave more power to parents, 2. Ensured access to the general education curriculum, 3. Encouraged non-adversarial mediation for conflict resolutions, and 4. Gave school officials more leeway in disciplining students with disabilities. These amendments mandated states to develop certain performance goals and indicators, such as dropout rates and graduation rates. Other 1997 amendments included changes in the IEP, which gave students with disabilities state and district-wide assessments. In IEPs, measurable annual goals, which included benchmarks or short-term objectives, were allowing educators and parents the opportunity to track progress using measurable outcomes. Both special education and general education teachers were at this time now required to be a part of the IEP team. Also, it was required that students with disabilities be included in state and district-wide assessments. This meant that the IEP team would need to consider modifications or accommodations needed to allow students to participate in standardized assessments. Concerning discipline of student behaviors, amendments in 1997 required that students exhibiting behavior or discipline issues be given a functional behavior assessment in order to create a positive behavior intervention plan that could be included and incorporated into the student's IEP. While school officials were given more leeway disciplining children in the same manner that they would discipline students without disabilities, a primary difference existed in that those with disabilities could not be suspended more than 10 school days. Certain violations would allow school officials to have students with disabilities in an interim, alternative educational setting for up to 45 days, as determined by the student's IEP team. More 1997 amendments also addressed handling disputes more amicably, limiting attorney fees, participation in IEP team meetings, education to adult incarcerated students, and extension of services to children who attended charter schools. The Individuals with Disabilities Education Improvement Act of 2004 had a goal of Congress to align IDEA with the Elementary and Secondary Education Act, also known as No Child Left Behind, in 2001. IDEIA sought to increase academic outcomes with the incorporation of best practices and the addition of highly qualified special education teachers. Schools were also encouraged to develop programs that helped to meet more students' needs in the general education setting and to provide assistance to all students who needed help. Part of the congressional updates of 2004 included important changes in IEP development, short-term and benchmark goals, IEP team meeting requirements for modifications, longer times for more comprehensive IEPs, changes and discipline policies, and resolution of disputes and attorney fees. Eligibility requirements were updated, ensuring that IEP teams would examine programming to determine the true cause of any student's problems. Would this cause be connected to or related to a true learning disability or simply to poor programming? Changes in funding also gave states greater flexibility to determine how funds would be used and to allow school districts to spend up to 15% of their funds on early intervention services. Response to intervention programs have been implemented in many school districts to help all struggling students. The 8 key components that represent major principles of IDEA are zero reject, identification and evaluation, free appropriate public education with the development of an IEP, least restrictive environment, procedural safeguards, technology-related assistance, personnel development, and parent participation. Zero reject states that all students are entitled to a public education regardless of disability severity and without conditions. All states must provide special education and related services to children living in their state who are identified with special needs, even if the child is attending private school. States must develop a child find system at the school district level to identify and support students who may need special education services. Identifying and evaluating students fairly and accurately is addressed in the IDEA to ensure that students are placed in a proper program and are receiving protection under the law toward receiving an appropriate education. There are strict guidelines and timing in the evaluation process from the start of the evaluation and consent to evaluate until school districts present their findings to determine eligibility for special needs services. Free and appropriate public education, known as FAPE, is also a requirement under the IDEA. With a free and appropriate public education, an IEP must be provided for all students identified as eligible to receive special education services. In order to meet the provisions of the law, school districts must provide special education services with specially designed instruction and goals set forth in an individualized educational program. Providing services in the least restrictive environment works toward educating students with disabilities with their typical peers. Examples of ways that students can be educated in the least restrictive way include developing an appropriate plan for student individual needs, providing various placements such as regular education classrooms, resource rooms, special learning support classes, special schools, instruction at home, and in hospitals and institutions. Procedural safeguards are important components that help to protect students with disabilities and their families. The safeguards are important by making parents participants in the special education process. Components of procedural safeguards are general safeguards, independent educational evaluations, appointing surrogate parents, providing cases be evaluated and taken seriously, and mediation for resolving disputes. Technology-related assistance is an important issue for many children and families with disabilities. There are many considerations when choosing technology devices for students to use depending on their specific needs. Vital to helping students with disabilities, technology-related assistance was provided by federal grants and incorporated into the IDEA. When assistive technology is deemed necessary for a free, appropriate public education to be provided, these amendments to the laws help to expand the availability of assistive technology to all students. IDEA also addresses development of personnel and the provision of the appropriate certification and license for teachers and support staff who work with students who have disabilities. Highly qualified teachers were required by No Child Left Behind by the year 2005-2006. in all special education settings underneath of the Elementary and Secondary Education Act. The final component provided for in the IDEA is that of parent participation. Parent involvement is crucial through the evaluation process, the development of an IEP, and subsequent meetings and decisions for placement along the way as their child progresses. Developing a strong partnership between families and school staff is vital to the success of the educational program for students with disabilities. The IDEA has provided students and families with free and appropriate public education in the least restrictive environment, protection under the law, assistance and funding to states and local education agencies, and effective assessments for program effectiveness.